Hi, everyone. Harry here to talk about the hearing in Judge Barrelhouse courtroom today for the Perkins Coie motion challenging Trump's executive order, basically just trying to punish them and take reprisal because they're a firm that has supported Democratic causes and gone against him for years. Now, that's not what the order purported to say, or not fully. It's actually like so much of the Trump administration work output, pretty poorly done and slapdash and tawdry. But it's going to matter as this goes forward. The order starts with security risks that are posed by Perkins Coie for all its dishonest behavior. But then, if you just read the first section, which sets out why Trump says they need to be punished, it really talks very little about security risks. What it suggests is Perkins Coie, have been dishonest and that they have done representations for undemocratic type action, including with liberal activists, propaganda folks like George Soros. In other words, flat out that they've opposed him. And indeed, the Trump himself brought a lawsuit against Perkins Coie for basically this same conduct, and it was dismissed. Now he's trying to make it the business of the federal government. All right, so we had a hearing today, and Judge Howell entered a temporary restraining order saying, no, you don't. Let's immediately figure out whether to put the brakes on this, and then we can move. She even suggested to a fast resolution and immediate summary judgment briefing, which is a way of saying they would take the agreed on facts and just write out who should win, who should lose, and she would determine it. Now, she came to the bench, obviously having written her opinion, a very pro opinion for Perkins Coie, because after the lawyers presented arguments, she read it right into the record. She hasn't formally issued it as we speak now because she's giving the government a chance to say a few things. But it was a real dramatic, I would say, showdown because basically what she said, let me take a step back and remind you of the order. It's the second law firm that the government has done this to. Trump says they'll do it to many more, and it basically orders them to have their lawyers at the firm have their security clearances yanked. And that means you couldn't do a lot of representation for government type cases. And it orders the government to look at the contracts with contractors who retain them as lawyers. Why? It's really quite clear that it's just Trump being as nasty and petty as he can be. And if you especially put together all his various statements about Perkins Coie, that among other things was on the other side of many of the 60 cases in which he got his brains beat in after the election trying to mount different legal challenges. But it's this very interesting dynamic that I want to really spell out so you understand what's going to be happening as this order by her goes up on appeal. Because basically what the lawyer for the DOJ said, and you wondered what poor schmuck was going to be kicked into service here, they actually took a political appointee, a chief of staff to Bondi, who I believe used to be with none other than Ken Paxton, the Texas AG, and had him really hammer home this notion that if the president determines, for whatever reason, that somebody is a security risk to the United States, the president has the authority to just act accordingly, and it's basically unreviewable. And there is DC Circuit law that makes it appear to be unreviewable. Plus, it's just the kind of proposition that a few justices on the Supreme Court would love to embrace. This is just the president, the lone officer under Article 2, deciding what's in the national security of the United States. Now, of course, the big point here is that's not true. It's a lie. It's the president enacting his petty agenda and doing what he does in so many instances, which is conflating the interests of the United States, the legitimate governmental interests in doing whatever the government legitimately does, with his own personal petty agenda to get back at a firm that has bedeviled him in the normal course of his litigious ways over the last several years. Now, he tries to point to a few things. He says, well, there was one of their people who were put on trial. Well, that's true by a Republican special counsel, except it was the jury immediately acquitted. He tries to say their representation were back in 2016, Hillary Clinton, Fusion GPS, and believe it or not, the Steele dossier. All that, comes up as well. One other case in which small sanctions were levied against the firm. All of this, by the way, is conduct by lawyers, especially Bob Bauer, the former counsel to Barack Obama, and Mark Elias, who went off and founded his own firm with many of the people in Perkins Coie. So it's by lawyers who aren't even part of it. And it purports to make trouble for every employee in Perkins Coie, depending on how you read it. And the government lawyer was trying to say, well, we don't know this yet. You have to wait until this actually happens. But if you read it for all it's worth, a clerk at Perkins Coie goes into a post office, could be getting into trouble. Okay, so she came out, did howl, and endorsed the views that the lawyers for Perkins Coie had raised, meaning what? First, no legitimate presidential interest at all. It's not really even executive action. It's just basically ultra vires is the legal term they use, meaning not part of your responsibilities. First Amendment, that was one of her two biggest things, and she saw two real problems here. One is that it's reprisal for protected speech, and that is all the representation they've done. He's reprising for that. And second, it's viewpoint discrimination. That it's because of their anti-government content that Trump is going after them. The government was trying to say, it's conduct. It's not speech. It's conduct that the president has determined poses security risks. But it was very vague. There was no more than could be said about that. And basically, the government lawyer had to keep retreating to we're not allowed to review it. This is just the president deciding, puts the security of the United States at risk, and the president alone can do it, and nobody else can do it. That's what he kept going back to. Howell was having really none of it. I mean, she was courteous, but she came out within 30 seconds on the bench. She said, "Don't play games with me," to the government attorney. And when she described it, she said, "This sends a chill down your spine," and basically said it just can't be that a president can have this kind of authority to basically punish their enemies or exact this kind of reprisal. So, First Amendment, and then finally, I just want to mention the Sixth Amendment, because right to counsel. It's the clients of Perkins Coie whose rights to counsel are really abridged. They can't choose anyone they want because Perkins Coie has been basically disabled, and there is showing that they're getting clobbered economically. All these big, and I know this anecdotally with them and Covington and Burling, all these big corporate clients are saying, I don't know if we can stick with you because we don't want to have a firm that's persona non grata and anything involving the government when they go. So it's really colossal damage and in the here and now for Perkins Coie. But the last point that Hal made very strongly is it's the Sixth Amendment claim. It's not just about the rights of the clients of the firm. It's really a kind of assault on the entire system, which depends on strong representation on both sides, and it's in the deepest kind of honor of the legal profession to represent unpopular viewpoints, if indeed that's what they are. What this really is viewpoints that the President of the United States has decided he doesn't like. But she brought it home, did Howell, to the whole kind of system of the adversary system for deciding who's right, who's wrong, what the facts are, in cases in general. So that was the theme on which she rested it. And there were a lot of statements that are really, show her horror at what is clearly a tawdry, nasty ruling. But just the dynamic going forward, I think, is going to be something like this. If the DOJ appeals, they're going to be saying, this isn't it's not any of this other stuff. It's just Trump deciding on national security, which Trump can do. And basically what's going on the other side, if they really push on that hard, she is coming back and saying, that's a pretext, which is a nice judicial way to say that's a lie. And that's really what is going on here. I think the courts understand it, but it's legally a tricky thing to call a coordinate branch a liar, and it's not normally something that you can use to just ignore or set aside an order. So it'll depend on how strict and dogmatic the United States is, whether they're sort of forced, the lawyers on the other side, to basically say this is about a pretext on the president's part. But very strong sort of first round in the district court from Howell, and we'll see what happens on the way up. This could be a tough case, or at least one that there's significant contrary feeling on the other side. Reed, Alito, Gorsuch, Thomas, Kavanaugh, if and when it goes to the Supreme Court. Or maybe they fold their hand in some way because it is just such an ugly order, but that's not characteristic of Trump. So very strong opinion by Howell, immediately entering a temporary restraining order and setting up a argument going on appeal about whether the president's say-so can just be used to basically screw his enemies. Let's call it what it is. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.